unfair labor practices can never be the subject of a compromise. It's contrary to public policy. However, you have the reformist labor union case. You have to be very careful in the reformist labor case. First, the reformist labor case was an arbitral award. Note the way the Supreme Court built its theory of the case. The Supreme Court began with a warning. We do not today overrule. Rather, we reiterate. Our two rulings in Korchenko and Armed Forces that unfair labor practice cases cannot be the subject of compromise. However, in the interest of maintaining the peace between the parties after a long, protracted fight, we will approve their compromise agreement of mutually withdrawing each other's case. But no, it is an arbitral award. So, to sum it all up, the doctrine in the case of Korchenko, the doctrine in the case of Armed Forces of the Philippines, that ULP cases cannot be the subject of compromise is still valid doctrine today. Because in the case of the reformist labor union, the court said very clearly, we are not overruling the doctrine. We are making an exception to the rule simply because of the nature of the relationship between the parties. Clear. So finally, to sum it all up, there is no such thing as freedom of speech in unfair labor practice cases. Very simple. Simply because if I were to ask you a question, I'm sure you will smile, if not laugh thoroughly. Do you believe all that your professor says in the classroom? Is he God? Oh, that may be sacrilegious. That may be sacrilegious, right? Do you believe all that your professor tells you in the classroom? The chances are you are. Although, of course, at the back of your head or at the back of your mind, you are almost telling him, I believe only because you are the one who's going to give me the grade. Other than that, there's no basis, right? So why did I say that? Because in labor law, the relationship between the employer and the employee are not the same. What to the employer may be only a suggestion, to the worker it is not a suggestion but an order. Why? There is a message giver, there is a message receiver, but the relationship between the message giver and the message receiver are not the same. There is an element of superiority. The employer is superior to the worker, correct? Because of that, the question of freedom of speech is not available in labor management relations now. Where have all the questions come from? The questions came from the relationship between 212 and 248 and 249. Simply because ULP has a very technical definition, clear. The second area of questions will come from the interpretation of Article 248A and Article 249A. In other words, is there interference? Is there restraint? Is there coercion? So you are back to your formula. The act and the thrust of the act. Act is interfere, restrain, coerce. thrust of the act is the right to self-organization and to bargain collectively. Clear? And the last part of the questions can come from the procedural connection and the jurisdictional issues involved in the civil and criminal aspect of the case. Before we leave ULP, may I ask you to take a look at your notes again. Take a good look at the law, and then you can indicate if there are other areas of the law that we did not fully discuss. So take a look. For the last time, it is paragraph 8 on both articles that you must master. And you must be able to imagine how it is going to be used. All right, any questions? Any questions?
Sir, from the judgment in the civil case, sir, when will the criminal case just start?
All right, okay. You are reading Book 7 of the Labor Code. You must be very precise. In reading Book 7 of the Labor Code, you will notice that the period of prescription of ULP is provided for there. The civil aspect prescribes within a period of 1 year from the time the cause of action arises, right? But you are referring to the civil aspect. Now, how do you relate it to Article 247? A reading of Article 247 will have to begin with Article 247 is protecting two rights of the worker: self-organization, bargain collectively. If these two rights are being protected, as it is actually being protected, a reading of Article 247 will tell you that if the right is violated, two causes of action can arise. One, civil, two, criminal. But unlike other laws, the two causes of action cannot run parallel with the other, meaning there can be no two causes of action filed separately, one criminal, one civil, at one and the same time. That means that the party whose rights are violated must first begin with filing the civil aspect of the case. The civil aspect of the case from a procedural standpoint as well as jurisdiction tells you that under Article 217 of the Labor Code, the labor arbiter has original and exclusive jurisdiction over all unfair labor practice cases. However, there is Article 260. You have to distinguish between gross and serious violation of the provisions of the collective bargaining agreement's economic, because it is not an unfair labor practice, which means then the civil aspect of the case must be filed first and wait until judgment in that case becomes final. meaning the labor arbiter's decision may become final if the labor arbiter's decision is not appealed. But if it is appealed to the NLRC, the decision of the NLRC cannot become final because if there is an avenue of appeal under Rule 43 to what? No, it's not Article 43. That's why I'm calling your attention. You can appeal to the Court of Appeals and then to the Supreme Court. So, at any of those stages, absent an appeal, the judgment can become final. So you have met one half of the requirement. Judgment has become final in the civil aspect of the case. Second, that in the civil aspect of the case, there is a finding that an unfair labor practice was committed, but in a civil aspect, meaning no penalty, because the remedy is cease and desist from committing the act. But there is the other half, and that is the criminal aspect of the case. Before the criminal aspect of the case can take place, there must be final judgment in the case of the civil aspect of the case. But no, there were periods of time here. All periods of time are told for the purpose of prescription, meaning stop. From that time on, it has become final. The door is open to file a criminal case. What is the prescriptive period? It is the penalty that determines the prescriptive period. Clear? So the prescriptive period defined in the labor code refers to the civil aspect, not to the criminal aspect. All right. So that answers the question.
Reg high daw, sabi ni Steph.
Problem. Strikes, lockouts is a long provision of the law. And I was reading the newspaper this morning. I promised all of you that I will go to the UP on Monday. I just discovered on the newspaper, although of course ignorance of the law is no defense, that Monday is a non-working holiday, because under the law, if the holiday falls on a weekend, it is moved to the first working day. Right? So then, one, I cannot keep my promise to get your material. I am sure the UP College of Law will be closed, beyond a doubt. Secondly, the Bible tells us that the Lord rested on the seventh day. In our case, we are resting on the fifth day, because we began review on Tuesday. We are resting on Saturday. Which brings me to the point, strikes and knockout is a long provision, and I don't want to leave it hanging. So I have two options: proceed and let it hanging, or let you go. I am not going to ask you what is your option, for the very simple reason that if I give you the privilege of saying so, I am on the receiving end of your options. At any rate, I will be able to keep my promise that I will do it tonight, because to be sure, my teaching outline is 46 pages, but I am already on page 33. So I can go back. Whether I will be able to do problem solving or not, chances are I will. If I will not, I will make arrangements for one extra day in August. All right. We still have a class this afternoon. On what?
Dean Abad.
survey. Well, I'm not going to do the survey, but I'll give you a copy
Yes.
of the survey I made.
Hey, Reg.
Okay?
Hi, Reg.
You'll get a copy in 2 years.
Reg, maaga
That
kami
is
umuwi.
more than enough.
Sayang, pumasok ka na lang.
And this is an exhaustive
Bigla siguro
survey.
magugulat din.
All surveys are on labor law, labor standards, labor welfare, they are all covered in this